Members, may I call to order the third meeting of the Bills Committee on Private Columbaria Bill. We have a quorum and it is also the appointed time for the meeting. Item 1 on the agenda, but now can we ask the administration team to come in first?
Item
1 on the agenda, meeting with the administration. On the 25th of October 2014, the Bills Committee received 26 deputations and individuals on their views and concerns regarding the bill. We also received 8 submissions from deputations and individuals who did not attend that meeting. The administration, at the request of the Bills Committee, has supplied its written response to the views of the deputations and individuals, and that is in paper CB bracket 2305/14 to 15 bracket 01. I will first of all ask the administration to take us through the paper, and then we can have a discussion on the paper itself. Attending the meeting today, we have a team from the administration comprising Mr. Christopher Wong, Deputy Secretary for Food and Health, Ms. Diane Wong, PAS for Food and Health, Ms. Chu Lan Ying, Assistant Director, FEHD, Mr. Thomas Leung, Assistant Director, Buildings, Ms. Olga Lam, Assistant Director, Lands Department, Ms. Christine Chair, Assistant Director, Planning Department, and last but not least, Ms. Cindy Chirk, Government Counsel from the DOJ. Welcome to you all. Shall we do this? I'd like to ask the DS to walk us through the response paper from the administration. Can we have a brief introduction? I can see that this paper is quite exhaustive in its response to all the points. I think this is a good beginning in that you give very detailed responses to the views expressed by members and the public. The DS? Thank you, Chairman. First, I'd like to thank the deputations, individuals, and also members for their views expressed at the last meeting. As you said, this is a response paper to the views and concerns raised. We have provided responses as well as some information. Allow me to spend some time on the paper. Many comments have been made, and please allow me to take some time to take you through the paper. First of all, let us go to B in the response paper coverage of the bill. At the last meeting, some deputations and members. Sorry, DS. Wouldn't you like to start with A, please? A is general. Those are overall views on the bill, and in fact, under A, the views are in support of a licensing scheme to do regulation. And we have noted those views, so that part doesn't need a lot of introduction. B, we have more concrete issues raised. So allow me to go through them, Chairman. Under B, 7 and 8, as you can see, have raised 2 issues, and that has to do with the coverage of the bill. The first view was on the current definition of ashes, whether we should also cover the turning of human ashes into synthetic materials, whether such should be regulated under the bill. And also at number 8, a religious point that some religious organizations may in fact be allowing their monks and other people to make use of the columbarium in a permanent manner. We have noted those views. We believe we need to attend to both comments, and we are still pondering what we should do. When the time is ripe, we will come back to report to members. And that is if we are really going to tackle these matters, whether we need to move CSAs, and we'll come back with a report later. And also under coverage, there is another point. Some members raised under point 11 that apart from regulating the operators, shouldn't we also regulate the intermediaries? When we drafted the bill, we actually thought about this, but we set priorities, and we felt that we should first of all focus on the licensing regime first. After that is up and running, then we can attend to other issues in stages. If the licensing regime will be implemented, if there is the sale of a new niche, it should certainly come from licensed operators, whether or not there is an intermediary. Therefore, as a first step of regulation, we believe that is more important, and we hope that that will be effective. So we want to focus on operators, and we may have to leave the intermediaries for the time being. And we are inclined to assist the Bills Committee in making the bill law first. And there are other views under this part. For example, because under the licensing regime, in order to draft or formulate this licensing regime, we have set out a notification scheme. In other words, it's an administrative system to process information. And I'd like to supplement here that since the gazetto of the bill on the 25th of June, most private columbarium known to us have already appraised us of the present situation. As for those not known to us, they have now become known to us, and we are still processing the information they submitted. We need to do some confirmation of that kind of information. With regard to information that can be established, we will be able to process the applications for exemption, etc., and we'll use the information as the basis for the licensing future licensing board to process such applications. The information is still being processed. And that is all about B that I would like to introduce. And maybe I can take members' comments or questions on B. Members who have arrived late should know that we are now going through the government's response paper from the administration. This is CB bracket 2305 stroke 14 to 15 bracket 01. The administration has now covered Part A and Part B of the paper. A is on general issues, B is coverage of the bill. So we have just got an introduction from the administration on these two parts. Any questions or comments on these two parts, please? Mr. Stephen Ho. Sorry, Mr. Wong Kwok Hing first.
I raised my hand just now. Thank you, Chairman. I have some questions for the administration. First, the period of the licenses, the maximum period is 10 years. Are you referring to the licensing period? Yes. For consumers who buy niches, they expect to possess it permanently. So it's the same for public Columbaria. Once you secure a niche, you can keep it for life. It's the same for private Columbaria. But after, when the bill is passed, the licensing period is only 10 years. Qualified people can only receive a license. Qualified operators can only receive a license for 10 years. As such, for consumers who buy or rent niches, what happens 10 years later? When they buy a niche, they expect to keep it for life. But then if the validity period granted by the government is only 10 years, then it's really different from what they expect. Can you guarantee that the license can be renewed 10 years later? The consumers will be very concerned with this issue. What if their licenses are not renewed? And for operators, they also face increasing operating costs. So would consumers be afforded any protection? So this is something the administration should address. Mr. Wong, let's do it this way. We are talking about the administration's response to the deputation's comments. He only talked about the categories A and B. What you said is out of categories A and B. So why don't we do it this way, Deputy Secretary? Perhaps you can go through all the categories, all the comments, and then before we open the floor to questions. So you can go through the rest of the paper first. Thank you, Chairman. I'll go through the remaining items quickly. Under Category C, the comments are on arrangements for pre-bill Columbaria. I hope you understand that the purpose of having these arrangements is that we have a lot of Columbaria who have been in existence for a long time and are already widely accepted by the community. But for some reasons, they might not be able to satisfy all the requirements of the bill, and we will grant exemptions. Otherwise, we will have to relocate a lot of these Columbaria. So we prefer this pragmatic approach. And a lot of pre-bill Columbaria would fall under this category, and if they satisfy certain conditions, we would allow them to continue to operate. And for pre-bill Columbaria to be able to enjoy the exemption, they must satisfy several thresholds. First, the period of operation. They must be in existence in the community for at least 25 years. And we drew the line at 25 years because from the consultation we understand that the public thinks that 25 years is a suitable time period. So in the draft bill, the line is at 1st of January 1990. So if for Columbaria, which existed before this date, then this threshold can be satisfied. And we also have other thresholds. Even after we grant the exemptions, these Columbaria have to follow other requirements as well. For exempted Columbaria, they cannot sell niches further in the future, and they have other responsibilities as well. And they have to spend money on management, and they also have to satisfy other statutory requirements and minimize disturbances to the community and the environment. So the point is, we do manage these Columbaria, but at the same time we will also grant exemptions under certain conditions. And in response to point 14, and in order for these pre-built Columbaria to continue to operate, we have some special arrangements. For example, they would have to pay the difference in land prices, but in some cases it can be exempted. We believe that these very old Columbaria, we believe that a lot of the money they earned were already spent on further development and operation. So if we ask them to pay for the difference in land prices, then they might be driven out of business, and that's why we have certain special arrangements. And some people are saying that we are being too lenient to certain Columbaria. I'd like to take this chance to emphasize that by allowing them to continue to operate, they must satisfy certain requirements. First, they cannot sell any more niches, and they must carry out certain mitigation measures. And this is basically our approach towards these pre-built Columbaria. And under point 18, and some people are concerned that after the licensing system is in place, we would have a vacuum period in which there are no licenses out there in the market. And some people suggested allowing these operators to continue selling niches during this period, and this suggestion for us is quite problematic, because at the end, if specific Columbaria fail to obtain their license, then consumer interests would be compromised. So we would prefer to stick with our original plan. After the bill is passed, any Columbaria, all the Columbaria cannot sell any niches before they obtain their licenses. And on to point 25 of the comments. Some groups are concerned that within the same premise, some parts are licensed and some parts are not, and they don't think this is appropriate. And after some deliberation, we are of the view that in some circumstances, let's say for a big premise, part of it has been in existence for a long time, and part of it can be further developed into Columbaria. So under the licensing scheme, these two parts can coexist at the same time. But I'd like to stress that in order to obtain the license, all the relevant requirements must be met, and there would be no exemptions. And even if a columbarium enjoys an exemption, the scope of exemption is clearly defined. When we grant the exemption, we would state very clearly the areas of exemption. We will only exempt areas where ashes are being interred, and other areas will not be covered under the exemption. If an operator would like to develop an area into a columbarium, they would have to file another application, and all the relevant requirements will have to be met. The operator must satisfy all the planning, lands, ordinances before they can secure their license. So we think that this would offer ample protection for the consumers. And the licensing board will consider their applications. So we think these protection measures would be enough. We would try to balance the interests of these operators and residents. And on to part D of the comments, details about specified instruments in point 30. As Mr. Wong said, the validity period was mentioned. I have 2 points to make. First, we think that the validity period of 10 years is appropriate because of a few reasons. For new Columbaria, they must operate the business on their own land. But on the other hand, for existing Columbaria, some of them are not operating on their own land. They might be renting someone else's land. Since we are not going to stop all these Columbaria from operating, our arrangement is that if an operator is not running the business on their own land, they must at least have a rental period of 5 years. We think that this is an appropriate way to deal with existing Columbaria. And looking into the future, we stress that the license can be renewed. And Mr. Wong asked that what if the license is not renewed under the law? There is a provision which states that for all Columbaria operators, if they close their business for any reason, regardless of their reason, if they are to close down, the law has specific requirements, and the operators must properly handle the ashes that are in their possession. For example, they must contact the relevant families to collect the ashes. There is a mechanism in place for operators who no longer wish to operate a columbarium. We have a set of rules governing niches and ashes. If operators cannot satisfy the requirements, the penalties are heavy. They might be imprisoned for a few years or receive a fine of a few $1,000,000. We think that these arrangements are appropriate. Apologies, the speaker is not on the microphone. For different licenses, the validity periods are different. For food or burial licenses, the period is about 1 year. For broadcasting licenses for TVs and radios, the validity period might be 10 years or more.
When we decide on the validity period of licenses, we have to be mindful of the nature of the business. If it is a new columbarium, it must be on self-owned land. But if it is a pre-existing columbarium, well, would be best if it is on self-owned land. If it is not, then we would ask them to have a tenancy of at least 5 years before we give it a license. And the validity period would be 10 years or the tenancy period, whichever is the shorter. Why 10 years? We would allow them to renew the license. Well, it's the same for other licenses. We hope there will be an opportunity to take a look at the operation of the columbarium to see whether it is still in compliance with the requirements, and also whether it can satisfy the licensing conditions. If there is not a validity period, we may lose that opportunity. I can also add that if you look at consumer protection clauses in Schedule 4, if you have the Chinese version, it is on page 99, 2D5. We would ask that in the interment agreement, it has to tell the buyer or renter how the period of interment can be renewed so that consumers can make informed choices. Just now, the DS said that if it should cease operation, there will be a series of measures to make sure that these arrangements are appropriate. But you are talking about people who rent the land, is that right? What if they are on own property? Usually, it depends on the land lease as to for how long they can hold the land. But if it is a pre-existing columbarium and if the land on which it stands is rented, then it depends on the tenancy. If the tenancy runs for over 10 years, then it will be 10 years. If it is for just 8 years, then the validity period of the license will also be 8 years. Okay, please go through the paper briefly and then you can take questions. In fact, the rest of the paper have to do more with procedures. For example, application procedures for reference to increase transparency, etc. We have already responded to those and I will not repeat. H is on the disposal of ashes. I like to say that there will be arrangements. As I said, there will be arrangements if the operator ceases operation, and we understand from the FEHD that we may need transitional arrangements for the placing of ashes. The arrangements are already there. And then we have a G, consumer protection. As our colleague has said, we would rely on the agreements mostly. And there would be mandatory clauses in the agreements. The purpose is to allow consumers to make informed choices. The agreement should include everything the consumer should know. If it is not such an agreement, it can be made void. That's the design of that mechanism. And then undertakers, K. people asked how we are going to regulate the undertakers. Let's emphasize that actually under existing ordinances, we already have tools to regulate them. To complement this bill, we are also going to tighten up regulation of undertakers. So the impact they make on people on a daily basis will be minimized. I think I should pause here. The other points are minor points. Right, thank you very much, DS. Can you now respond to the question raised by Mr. Wong Kwok Hing, please? Mr. Wong's question was whether the validity period of 10 years is appropriate. We were trying to explain that we have considered a few things in coming up with this 10-year period. First of all, those people who do not own their own land. So the validity period of the license would be shorter, but the shortest will be 5 years. As for those who own the land, we can give them a license of 10 years. And as my colleague said, we think 10 years is appropriate because every 10 years we should have the opportunity to review its operation before the license is renewed. We believe that is a desirable arrangement. And I think Mr. Wong is asking what happens if the license is not renewed. As I said, a licensed operator, if he goes into winding up, we would ask him to appropriately arrange for the ashes to be removed, or else he would have criminal liability. We have 7 minutes for each member, please. Mr. Wong, the clock is ticking. Is it that my time is starting? No, it is already in your time. You said 10 years is appropriate, but I question such a policy. I think it's not appropriate because, number one, you're saying that if the operator owns the land or if he doesn't, they are put into the same category. I think this is not appropriate. If the operator owns the land, why can't you tally the validity period of the license with the land lease? Because consumers would buy a niche and they would consider it a permanent arrangement. So why can't you allow a permanent license? Now, of course, if the land is rented, it should be pegged to the tenancy period. That I can understand. Number two, if by the end of the license period, if the operator cannot arrange for the ashes to be appropriately removed, he will be subject to heavy penalty. I think there is a loophole here. You can subject the operator to heavy punishment, but if he wants to reap the profit, he would have done it already. And even if you subject him to imprisonment, he still will not discharge his responsibility. And you said you would try your best to liaise with the relevant people. What if you fail to do it? And if the operator fails to liaise with the contact person for ashes to be removed, then what happens? I think this has everything to do with the very short validity period of the license, i.e. 10 years. DS, I understand the question. I think he is helping to make operation sustainable for the industry. We indeed have taken a look at the actual situation. We believe most of the operating Columbaria would like to operate on a permanent basis for religious or non-religious reasons. We believe we should allow the industry to develop on a solid foundation. The license will run for 10 years, and we don't think many of the operators will cease operation after 10 years. But we have to have a stringent mechanism to take care of eventualities. If in case an operator goes out of business for whatever reason, we should have an appropriate arrangement in place. The follow-up question is, of course, okay, there is the law, but people may not comply with it. And okay, we say we subject him to heavy punishment. But we have a fallback. In that circumstance, if the operator cannot remove the ashes in an appropriate manner, the department will take over the job. The arrangements is actually in the law, and basically it would be for the FVHD to go on site, and we will freeze the operation of the site over a short period, and then we'll take stock of the number of niches and ashes. We don't want that to happen, but we really have to have a fallback to take care of eventualities. Many consumers actually want to have a permanent arrangement, but there is a technical issue. In Hong Kong, land leases are limited. Well, okay, you can peg it to the land lease. It's just like buying property. If you can have ownership for 99 years up to 2047, then at least that can be done. Your question is clear. DS. We would like to have the opportunity to revisit the operation of the columbarium in question every 10 years. Well, you are talking about a manager and a consumer. Those are two different perspectives. As the regulator, you want that to be done, but as a consumer, the consumer may think that the niche would be held permanently and should not be subject to a validity period. Well, I was trying to say that we need to accept a situation where land leases in Hong Kong are also limited in time. So can you just peg it to the land lease? We have considered that, but we have balanced views. In fact, we cannot have anything permanently. We cannot have a permanent arrangement because we really would like to be able to review the operation of the license on a regular basis. And we think 10 years is an appropriate period. Sorry, I need to interrupt. You want to regulate them, it's your business. But even for buying property in Hong Kong, we have a land lease. It is not permanent either, but at least it will be for 99 years. Mr. Stephen Ho, thank you. I will follow up on this very question. The administration said that if the license is renewable, then you want an opportunity to revisit the operation. But you don't need to do it every 10 years. You can assign the license and then you peg it to the land lease. And then every 10 years you can always go and check to see whether they have complied with regulations. If they don't, you can revoke the license. In that way, you can do what you want to do subjectively, and then you can also satisfy the aspiration of the public that the niches are held permanently. And when I raised my hand for the first time, I had wanted to ask questions on A and B because I was afraid that you might forget the issues. And at B, they talked about issues known to the administration or unknown to the administration, and they said that they have found solutions for those. And I'd like to know what they mean by unknown issues. What is your expectation of unknown issues? And also, Mr. Wong, you talk about minimizing impact on nearby residents, and you repeated the phrases, some work has been done, some special arrangement is there, some measures have been taken, but you have not been specific in your proposal to minimize impact on nearby residents. Can we have something specific, please? DS? I'll take care of the second question. I think I could not follow the first question asked by Mr. Stephen Ho. The second question was about worries of nearby residents. I like to say that under the licensing system, if a place is used as a columbarium, and in order to get approval, they need to go to the town planning board, and the town planning board will conduct public consultation, so the public can raise their concerns.
So the town planning board can make the final decision. I'm not going to repeat the procedures. And when the matter is taken to the licensing boards, the private Columbaria licensing boards, as stipulated in the law, the applicant must satisfy certain requirements before they can secure their license. For instance, their daily operation and management, and they must convince the licensing boards before they will be granted a license. And at this stage, the licensing board can also exercise discretion and the board can listen to views from the residents at that time under their discretion. So we have, in designing the requirements, we have considered the views and the voices of the residents, and we have considered the residents' concerns. I'd like to add something with regards to the first and second questions. And some licenses will last until 2047 or 2037. And are we going to not review these Columbaria? When you look at licenses for TV stations and radio stations, the validity periods might be 10 or even more, 10 or 20 years. Rather than suspending their licenses over breaches in requirements, according to the FEHD's experience, as long as the operator is not in breach of any requirements, their licenses can usually be renewed. So we must strike a balance. We must strike a balance between consumer interests and compliance from the operators. And for the second point, as I understand, the Assistant Secretary mentioned the notification mechanism. The FEHD received 140 such cases, and the breakdown is 124 and 16. The 124 cases refer to cases known to the administration, and they make up more than 70% of all the cases in the Development Bureau. And for the remaining 16 Columbaria, they are not on the list of the Development Bureau, but they have came forward and let us know of their existence. I'd like to follow up on the question on interring the ashes. You said there will be heavy penalties if the ashes are not properly managed. I think you have to strike a balance. You have to provide some leeway for operators. As Mr. Wong said, it might not be very easy to contact the family of the deceased. Apart from contacting the family of the deceased, would you have other approaches in order for operators to comply with the license? Maybe. Thank you very much, Mr. Ho. Let me tell you how what we do with the ashes. The operator has a list of with contact details of family members of the deceased. Let's say if there are 100 sets of ashes in total and 20 of them are unclaimed, they have to inform the Food and Environmental Hygiene Department, and in such cases we will bring the ashes back and we will post announcements on newspapers and invite the relevant people to collect the ashes, and if these ashes are still unclaimed after this period, we will process them. Mr. Lee Chuk-yan. I've heard a lot of what the government would do with illegal private columbaria. I see a problem in your approach. You are encouraging or allowing people to break the rules, and they can still get a license, especially for columbaria that were in existence before 1990. But actually, there weren't a lot of columbaria in existence before 1990, but there are a lot after 1990. A lot of them have breached the rules. They have developed illegal private columbaria underneath government land. And under their own temples, they have breached other regulations, but still they could enjoy exemption because they were in existence before 1990. So you are virtually encouraging people who don't follow the rules. You are not penalizing them. So what is your view on this? I think you should be more stringent on violators. So what is your view on that? You have repeated your views, but you have not responded to comments on illegal columbaria developments. Chairman, in 2014, on the 18th of June, unless this is where we draw the line, if the columbaria only existed after 8 o'clock that day, they must apply for a license. And even for columbaria that existed before the 18th of June 2014, they must completely comply with all town planning ordinance requirements, and they must comply with all relevant land ordinances. They have to pay for the differences in land price. And if they were established before 18th of June 2014, before 8 in the morning, and they must also be in existence before 1990, before they can enjoy the exemption. So if an applicant wants to file an exemption request, they must satisfy different requirements. After the 18th of June 2014, after 8 a.m., they cannot lease out or sell any vacant niches. So this is there's a freeze in sale, and they have to work on the compliance, and they must satisfy all the buildings requirements, and the BD will impose additional conditions in order to minimize disturbance to the residents. If the operator decides to continue, they have to spend a lot of money to in order to continue their business and comply with all the requirements. Having considered all the factors and the fact that over the consultation period, the residents would like us to adopt a pragmatic approach and hence this policy. If the Columbaria existed before the 1st of January 1990, for Columbaria that stopped developing after 1990, then we won't have a case here. But for Columbaria, which existed before 1990 but then developed extensively after 1990, you mean Columbaria, which developed extensively between 1990 and 18th of June 2014. That's the same for illegal structures in. I think the case is the same for illegal structures. They have to file another application. The buildings department have certain requirements, and the operators have to comply with them. I understand the members' concerns, but pragmatically speaking, between 1990 and 2014, you cannot identify the time. You cannot identify exactly when they began to expand. Were they in existence before 1990 or after 1990? You can tell from certain legal documents like land leases. How many cases do we have? How many Columbaria were in existence before 1990 but only developed extensively after 1990? I believe you can tackle Columbaria which were in existence after 1990, but what about for those who existed before that? Do you have such figures on hand? Such figures are rather hard to obtain. We are talking about a long time ago. There's a real question mark whether Columbaria operators can provide such figures. And even if we check the sites, it's very hard to ascertain when they were in existence. At this stage, we don't have a lot of accurate information. What's the difference between an exemption and non-exemption? For exempted operators, if they are exempted, they cannot lease out or sell any niches after the 18th of June 2014, after 8 a.m. From the administration's perspective, after granting the license, they would regulate the operators instead of the customers. We are talking about private agreements between Columbaria and consumers. They are not under control of the government. So in terms of the law, are you going to introduce clauses to protect the consumers? Perhaps you can work on the license requirements to protect the consumers. I think we have to do something with the validity period. Suppose the operator is operating on its own land, so they have to they can operate throughout their land lease period. Are you going to require operators to display their validity period? in a prominent spot so that consumers can know when they patronize this columbarium. Do you have such requirements or penalties in place in case operators don't comply? So from an operator's perspective, that would give them a better peace of mind, and the government can better manage these columbaria. The validity periods might be different, so it would be better if we make it clear to the consumers. Let's say if the period is 3 years or 5 years or 10 years, so they can make their decisions.
當中你哋講一啲叫構築物呢
In the license, you talk about structures. You say you have to have safe structures, including village houses, and it may be larger structures approved by the buildings department, but things are quite special in the new territories. There could be large buildings built before 1990. They are non-small houses, but they were allowed to exist. And the buildings department did not take action. And there was this case. I can see ashes being moved into the structure, but it is not operating in public, so to speak. Afterwards, if you have the licensing scheme, you say you draw a line somewhere, and that is before 8 o'clock on the 18th of June 2014. That is where you draw the line. And strictly speaking, this structure belongs to having operation before 8 o'clock on that day, but they have agreements, and it's not hard for them to write out these agreements. Would you regard that case as a pre-existing columbarium? But then people living around it have strongly objected to it. So do you think that can be licensable? Chairman, Ms. Wong, I can answer the question in two parts. Number one, the member is concerned about consumer protection. I think we have had an in-depth discussion on the validity period. We have explained that we need to strike a balance, and we have heard the comments. As for consumer protection, we can do it through agreement clauses. I think this bill has taken one more step as compared to other regulation regimes. We have said in the law that an agreement must be signed and the clauses must be specific, and in Schedule 4, disclosure is regulated. If this is not complied with, the consumer has the right to make the contract void. Now, I'd like to also ask about the validity period. I was saying that in Schedule 4, under 2B5, they have to include the license validity period. Right. Now, apart from agreement clauses, there are provisions in the law whereby the license must be posted up in a conspicuous place at the premises. This is another kind of protection. And the second question on structures. In formulating this bill, we had a very lengthy discussion on this. In Schedule 2, we had analyzed all the different structures, those pre-1987 or those pre-1961, etc. Technical details are involved. And maybe we need to supply written information to members after the meeting. Since these are legal provisions, and maybe the industry and the public may not be very familiar with these, and we actually would write out guidelines and also codes of practice for that to be released to the public and the industry so they can follow them. I still don't understand. If the structure has not been approved by the Town Planning Board because it was already built before the establishment of the Town Planning Board, do you call it a legal structure? We know it may be illegal, but we cannot demolish it, right? Well, no, actually, this is not pegged to the Town Planning Ordinance, but rather the Buildings Ordinance. But it has been evolved from different ordinances over the years. The application of the BO to the urban area and also to the NT, that was done in different years. So we can give you a written response. I think it is difficult for members to grasp if we just give an oral answer because the history of evolution is long. Who else would like to speak? Mr. Wu Chi-wai. Thank you, Chairman. I'm sorry I'm a little late. Maybe my question has been covered. I'd like to seek some clarification. I could see the DS was saying that many niches would have been sold by Columbaria. Well, by nature, such niches, if they are vacant, will not automatically be legalized. You are going to legalize only niches with the interment of ashes only. So, do you know how many such niches have been transacted? Is it that when they come for registration, you would draw a line there? So, do you have a concluded figure? And also, the DS said that there is an agreement to be signed between the consumer and the columbarium operator. And if the operator cannot get a license, such vacant niches would also become illegal. And it is said that the agreement can be rescinded. I'd like to know how that can be done, because I understand that the majority of such niches are not the subject of an agreement. Usually it is because of donations made to a columbarium, so you have this niche for your use. Now, I'd like to know the technical side of things. If such niches have been transacted, I hope consumers will be protected. Even if we have this new law, I don't want to see consumers suffer and suffer losses because they have bought such niches. I think this is quite fair because it is the columbarium which cannot discharge its responsibility. And of course, if we have a macro interpretation of contracts, there is a direct responsibility on the part of the columbaria. I'd like to ask you, therefore, what are you going to do if in the end such niches are regarded as illegal? How can the agreements be rescinded or cancelled? I can ask my colleague to give you the information later. Before the law comes into existence, agreements might have been signed. If the agreements are to be enforced, consumers can resort to consumer protection clauses to enforce the contracts concerned. This is what it happens now. But after the bill will come into operation, the law will stipulate that in new agreements to be signed, and if they apply to niches, certain information must be disclosed. The consideration, the services included, and arrangements upon closure of the columbarium, all this will be protected by law. But if agreements are signed before the bill comes into force, then we can only resort to existing redress channels, say civil claims, Chairman, let me, Mr. Wu. I think I need a longer answer. We know that to be the case. If that is what you are saying, it means you need to do nothing. No, let me supplement. If niches have been the subject of sale before 8 a.m. on the 18th of June 2014, and yet if the niches do not have any ashes entered, we know that is happening. And we said before that we didn't want to see any abuse, so we had written clauses to address this. And even if we revisit the clauses now, we think they are reasonable. You asked us whether we know the figure. Well, through the notification system, we know that the figure is considerable, and that is in the tens of thousands. In the press release, we said that we understand that whether it be the operator or the clients, we know they have concerns. Now that we know the figure, we will consider how to handle this issue, because we do understand that there are genuine cases and they should be assisted. As long as there is no abuse, if evidence is submitted, then we'll try to see how the bill can help them. Maybe at the next meeting or later, we will let you know how we are going to deal with this. Say there may be a couple and one party has deceased before the 18th of June 2014 and the ashes are already in the niche, but the other party is still living. So if we can see that kind of evidence, and with a CSA, we can allow the bill's provisions to provide for such scenarios. Okay, I understand you can have special arrangement for such cases. I think that is the ethical thing to do, but you cannot rule out cases where there is an agreement signed between the operator and the consumer, but the agreements may not be in black and white, and so no legal action can be taken. As you know, in the majority of cases, we do not see such agreements or contracts. As you know, there are many niches that have been transacted but are still vacant. Now, what can the consumers do? You know, they have paid hard currency, cash, to the operators, and yet after the bill comes into law or comes into force, the niches would automatically become illegal. Well, yes, under the notification system, the FEHD was collecting information and it asked the operators to supply such agreements, if any. Please let us have more time and see what information we have already got, and to come to grips with the scale of the problem and report to the Bills Committee later. We have asked the questions. Let us consolidate the information we have collected. As a matter of fact, you should supply that information. But I think members have focused on one point, and that is the consumer has been told that there will not be any limitation to the holding or possession of the niche. Now that there will be a validity period of the operator's license, the consumer may feel his interests eroded. Now, you call it a validity period, but that is only for your management purpose. And maybe the operator will deliberately mismanage his premises, so you revoke the license, and then what happens to the niches? Well, that shouldn't be the case. We are only talking about agreements that will be signed after the law is enacted, and it does not apply to agreements that have already been signed. Can we have some clarification? Let us go back and get hold of the information. We are only talking about agreements that will be entered into after the law is in force. Well, as to previous agreements, we cannot do anything about them because they have already been signed. Chairman, I think we need to clarify something. We asked for information, and very often if there is an agreement, the validity period would be up to 2047. So it is almost permanent because the land lease will only be good until 2047. But here we are talking about a license, and the two can be separated. The license is for regulating the operator and his management of the premises. But as for agreements entered into the operator and the consumer, that will be in black and white, and the consumer will know that the niche will or can be used until 2047. But if the license is revoked, there will not be the columbarium anymore. What happens to those agreements? In the new agreements, there will be a clause. Say if the agreement is for 10 years, and if the license period is earlier than 10 years, then there must be a clause to provide for the return of or refund. But that only will happen after the law is in place. What about previously signed agreements?
Maybe I'll defer to the legal counsel. The bill is prospective in nature. After the bill is enforced, only contracts signed after the bill is enforced will apply. For contracts already signed, it's very hard for the government to intervene. But if you revoke the license, so who is going to manage the columbarium? And the niches are still there. For the consumer, they have a responsibility to contact the operator, and they can adopt, they can take legal or civil action to secure their own interests. It's still my time. Okay, you're up next. The situation is the consumer has already signed a contract with the operator, and it will last until 2047. But right now you say you're going to conduct a review every 10 years. If their license is revoked, what happened to the customers? I'm talking about old contracts signed before the 18th of June. The law cannot cover contracts signed before the 18th of June, as I mentioned. We cannot protect such deals. As my colleague said, if these contracts were signed before the bill came into force, the consumers can only take civil action if they think their interests are compromised. The issue of land is very clear. The validity periods of the licenses has no relation with the land lease period. Even if we grant a 10-year license, operators can sell niches after they secure the license. And if they stipulate in their contracts that there's a time frame, let's say the niches will be managed until 2047, this is acceptable. As long as consumers know what they are buying. If the contracts says the validity period is only till 2023, for example, then the price should be cheaper. I hope that clarifies things. Mr. Stephen Ho and then Ms. Sid Ho. I think a lot of people wouldn't understand what you mean. You said for new contracts, the validity period is 10 years. But are old contracts still valid? let's say if the operator was in breach of certain land laws, if the operator could not possibly expect that their rights of operation will be revoked. If you cannot answer this question today, can the administration work with your lawyers and provide an answer at a later stage? I asked the same answer in other panel meetings before. You know that some operators would be granted a license, some will have their licenses revoked, some will cease operation. We need some figures, and we need to know the total number of niches involved, and we have to know whether the government has enough temporary niches to tackle this problem. And if the supply of the private Columbaria market is going down, the prices of niches will go up as well, and there will be more people waiting for public niches, for public Columbaria. So would that affect the waiting time? Will you have any mitigation measures? Thank you, Chairman. I'll try to answer the first part of the question first. It's about the contracts. For operators who cannot satisfy the requirements, and if they've signed contracts with consumers, as we did remind consumers not to make very hasty decisions before thinking about their own interests. If they have if they run into any problems, they can consult lawyers. And with regards to the figures, how many operators can get a license, how many cannot, how many will be exempted, etc. It's decided by the licensing board. How do we know the figures? We can only secure certain information and share them with the licensing boards. For the temporary storage, if demand goes up in the future, we had discussed this point, and in the coming years we will have at least 47,000 public niches, and we will closely monitor the situation. And for public niches, for new public niches, there's no waiting list. The waiting list is only for old niches. We are trying to get the support from district councils, from Sha Tin DC, etc., coming up with the support of district councils, and if our funding application is passed at the Legislative Council, we can increase the supply of public niches in order to facilitate the demand. I think what the Deputy Secretaries said wasn't very reasonable or logical. The review was conducted at a later time, but a lot of contracts were signed a long time ago. I understand that you cannot provide very specific figures, but let me rephrase my question. Will you have enough niches for contingency purposes? Will you have enough backup niches to deal with any contingencies? If we have 50 or 100,000 people requiring niches, and if you don't have any storage space for them, it would be very unreasonable. As my colleague said, we expect to provide at least 47,000 temporary niches, and we have room to increase this figure if necessary. And we have done some preparatory work on that, but I cannot say with certainty that we can provide at least 47,000 temporary niches. Thank you, Chairman. The administration stressed contracts, but after the first poll, how many of the contracts are actually proper with the rights, with very clear provisions and clauses, and how many of these contracts are very ambiguous or unclear? Can you tell us about the situation of these contracts? How many of these contracts involved the sale of niches before the bill is in force? And how many of these contracts were incomplete? We are talking about tens of thousands of sold niches that are not occupied. In the legal framework, consumers paid for their services. If because of breaches by specific operators, let's say if they breach certain rules or try to dodge the law, the responsibility shouldn't be on the consumer. But you have stressed all day long that consumers can take legal action or civil action, or else there's nothing they can do. Should you have a mechanism in place to validate this kind of contracts in order to make sure that such contracts are effective, and in case of any problems, the consumers can then try to recover their losses. You cannot leave the consumers all alone, because when the case is taken to the court, the validity of the contracts might be questioned. They might say that it's not actually a contract, it's just a receipt for oil money. And if any litigation must follow, then at least the consumers can do something, or else they cannot do anything. I'd like to follow up on the point Ms. Sit-Ho mentioned. After the bill is in force, certain wall constructions might be illegal and they cannot house any niches anymore. And what do we do with these niches? The people can wait for public niches, but in the meantime, storage is necessary. Would the FEHD have any warehouses that might be that can be used for record purposes? Is this something the FEHD can arrange? And if the government can do that, it will show that you have considered this aspect. And for others, they have to obtain a proper niche by another way. So if in case the niches are cleared, what can we do with the storage? Before the bill is in force, for any type of transactions, both parties must understand their rights before signing it. And they are protected by civil and legal framework. And before the notification scheme was announced, we looked at samples of contracts in the market, or else we cannot come with these detailed legal clauses. There are many kinds of contracts. Some of them were drafted or endorsed by lawyers. There are different kinds. And we have learned from these contracts. And in our provisions, we stated what kind of things must go into the contracts, and we will issue guidelines to consumers later on. So if you ask whether we understand all kinds of contracts, to be honest, it's not possible. Through the provisions, we hope to help the operators and consumers.
Secondly, the handling of ashes. In the LegCo brief, we detailed the handling of ashes, as this is the responsibility of the operator. If he has to cease operation, there will be a time limit, say within 12 months or 24 months, depending on the situation, to arrange for ashes to be collected by people who have the right to collect the ashes, and also whatever has been buried with the ashes. In some circumstance, in a monastery, for example, it can arrange for the ashes to be housed in another monastery, but then the operator will have to tell people where the ashes will be relocated to. If he cannot appropriately conclude the process, the FEHD can take another process to inform the contact persons for them to collect the ashes and articles. So in the law, we have specific arrangements already for the relocation of ashes. I'd just like to ask the FEHD whether it will arrange for a warehouse. No, 47,000. They are not niches, but they are for temporary storage. No worshipping will be supplied. We will not do it in public ashes because there will be a moral hazard. Yeah, I understand that. These are just temporary storage spaces to take care of ashes that are displaced by illegal operators. Any other questions on the response paper? Members? I don't have any names recorded. If not, we have another paper. The ALA asked the administration some questions, and we have a response paper, and this is CB bracket 22338/13 to 14 bracket 08. We need to use that paper only when we do clause-by-clause examination. Okay, that is all for the response paper. Do you have other questions that you'd like to raise? In other words, general policy questions or other general questions. If you don't have those questions now, we can now go into clause-by-clause examination of the bill. And as you can see, this is quite a thick bill, and we have to go through the entire bill clause-by-clause. I'm sure we can discuss the clauses one by one. If members do not have general questions now, we can start clause-by-clause examination of the bill.
Okay. 係嗱咁樣如果咁樣情況咧，一係咁樣。
Well, since the administration said that at the next meeting it will provide a work plan and also to introduce the entire licensing regime and other matters. If that's the case, let us wait for the next meeting when the administration will supply the relevant work plan before we carry on I think if there is nothing else, we can adjourn the meeting today. Shall we do that? Is that acceptable to you? Because the administration will give us a more detailed work plan at the next meeting. This is a long bill, and I think a lot more discussion will be triggered. Okay, if that's the case, let us adjourn the meeting if there is nothing under AOB. The next meeting will be held on the 15th of December, on Monday at 4:30. Thank you. Meeting is adjourned.
點睇啊？